Hello, everyone. Welcome to CCA live webinar on partner visa pathways. In this webinar, I'm going to discuss various partner visas available for in Australian migrations in terms of prospective varies, offshore partner visas, onshore partner visas, what are the key criteria for those partner visas, what the requirements are, what the eligibility, and what is the sponsor eligibility to sponsor for these visas, and most important things, what are the key factor by which the partner visa is refused most of the cases. So I'm going to discuss all those issues in this live webinar. Myself, Harbi Sani, Registered Migration Agent, CECA. Let's begin with, I'm going to upload the slides for you. So let's begin with the partner visa. So what the partner visa is, the partner visa allows an applicant to live in Australia based upon the genuine relationship, and your relationship must be with any Australian citizen or Australian PR resident, or that can be eligible New Zealand citizens. If your partner is one of these, then you can lodge partner visa on the basis of your eligibility criteria, and also depends upon your genuine relationship with such sponsor candidate. The most important things, the partner visa are assessed based upon the genuineness of the relationship. So documents are evidentiary to show this relationship, but genuine relationship is quite important. So let's begin with the three categories of partner visa available in Australian migration. The first is subclass 300, which is a offshore visa, and this visa is also called prospective marriage visa. If you're going to apply this visa because you're going to marry with an Australian partner or Australian PR resident or eligible New Zealand citizens, and then this visa is for you. Second class is subclass 309-100. It is a offshore partner visa. So this visa is a temporary to permanent transition visa. So 309 is a temporary visa, and 100 is the permanent visa. After 2 years, they grant you, which is a actual Australian PR visa. The same category of this subclass, like 309-100, is subclass 820-801. The key difference is this visa is for onshore applicant. If you are in Australia already, then this visa is for you. And again, 820 is a temporary visa, and then it is converted into 801 permanent visa after 2 years, or depends upon your circumstances, how genuine your relationship is, how long it is, if you suffered from any family violence, or you have a child from the relationship, it depends. So how the permanent visa is granted to you. So I am going to have more details about these visas. So let's begin with subclass 300 first. Before that, let me explain you the sponsor eligibility. So who can sponsor for a partner visa? So as I tell in the beginning of the session, so the sponsor must be Australian citizen or Australian permanent resident or eligible New Zealand citizens. So the sponsor must be at least 18 years of age, must meet character requirements, have to provide the police check or Australian Federal Police check as well, must support applicant financially and emotionally when visa is granted, have to give the declaration for this visa. If is offshore, then affidavit; onshore, then statutory declaration, depends upon the state law. And the limitation on sponsor, the sponsorship could be refused if sponsor another partner in the last 5 years. So if you're going to sponsor some other, so you have to wait for 5 years. So before that, you can't sponsor the second applicant. Secondly, if he was sponsored on partner visa, again, still he have to wait for the 5 year of time to sponsor other applicant for such visas. And the sponsorship could be refused if the first reason I told, within the 5 year, if they're going to sponsor some other applicant, another if they convicted for any uh, criminal offense or any domestic violence charges, still the sponsorship for partner visa could be refused. So this is very important and very strict law in Australia against family violence. So let's begin with the visa subclasses. First of all, 300, uh, prospective marriage visa. So this visa, you can enter Australia to marry with your partner who could be Australian citizen, PR, or eligible New Zealand citizen. And the condition on this visa is you have to marry with that sponsor within the time frame the visa is granted, which is usually 9 months. And after marriage, then you have to apply the partner visa 820, 801 to permanently stay in Australia. So eligibility criteria for this visa: the applicant must be 18-year-old and be engaged with the sponsor and must met with the sponsor in person and intend to marry with that sponsor within the visa validity period, must have genuine relationship, and also meet health and character requirements. That is quite important. And sponsor must be eligible Australian sponsor and provide commitment in terms from statutory declaration that he going to support the applicant financially and emotionally. The main evidences to show this genuine relationship when you're going to lodge the visa application. So first of all, the notice of intended marriage. So when you're going to marry with the sponsor, because this visa is specially granted to you to marry that Australian sponsor. So you can provide venue booking and reception booking where the function going to be organized, and the wedding invitation or draft plans uh, for the celebration, and the celebrant confirmation that he is booked for such and such date and going to solemnize the marriage ceremony. Other evidences, like if you did some purchase like rings or any other things for the marriage, that you can also include in visa application. The most important things are relationship evidences. So the travel history together, phones history, WhatsApp or any other chat messages log, and joint future plans, social evidences in declaration in on 888 forms, which are officially generated from Department of Home Affairs. So this on this you have to supply at least two of these 888 forms, which must be signed, and statement must be mentioned by Australian citizens or any Australian permanent resident, and they have to provide their ID as well with these forms. Uh, and family involvement evidences, affidavit from your parents that you can include. So these are the main requirements when you lodge prospective marriage 300 visa. Second category, subclass 309 100, which is again a offshore visa. When you got married and applicant is offshore, you don't have any visa to come to Australia. In that case, you can apply 309 100. And most important thing, these are different subclasses. 309 is different, 100 is different. 309 is temporary, 100 is permanent. But at the time of application, you apply both classes together. So fee had to be paid one time. Uh, and after 2 years, the department consider for subclass 100 that they check that your relationship is genuine and ongoing, and then they grant you this 100 visa, which is a permanent visa of Australia. So this is a combined application, and main eligibility criteria. So you must be married or in de facto relationship with your sponsor, and The relationship must be genuine, of course, and continue ongoing. Third important thing is you must not be related with the sponsor in family relationship. If you have any family relationship with the sponsor, they are from the same family, uh, they far cousins like that, they're not acceptable, and also meet the health and character requirements. So you can also lodge this visa if you are not married but you are in de facto relationship. So de facto relationship is you are still in a relationship together with the sponsor and living with the sponsor from last 12 months, or your relationship is legally registered, then without marriage you can still eligible to apply this class of visas, but have to show that genuineness of that relationship. So evidence, a lot of evidence is you have to provide to prove your de facto relationship. And department assess this relationship on the basis of four characteristics like financial aspects of your relationship, nature of household, social aspect of relationship, and your commitment towards your genuine relationship. In financial aspect, you need to provide your joint bank statement, shared bill, shared expenses, if you money transferred each other, uh, and if you own any share asset like car or property. So all this come under financial aspect of the relationship. Second one is the nature of household. If you have legal agreement together, or and having same address to share, the utility bills of the same address, another shared responsibility. So all these characterize under house nature of household responsibilities. Social aspect, you can provide friends and family acknowledgement, triple eight forms, photo, or any travel bookings, or any hotel bookings. You spend time together. You went somewhere were on the honeymoon. So all these evidences you need to provide to prove your social aspect of the relationship, means that you are recognized as a couple within the society. That is the main motive. Third one is your commitment for your genuine relationship, like your future plans, uh, how you're going to relocate and going to spend time together, your communication evidences, relationship statements. You have to provide each and every step when you met, and how your relationship developed and how it's continue and ongoing. What is the future plan in your life? So everything you have to state in your relationship declarations. Third category, subclass 820-801, it is same like 309-100, but the key difference is it is an onshore visa. When both applicant are onshore, sponsor is onshore, and applicant also in Australia, then you can apply this visa 820-801. Again, like offshore visa, so its main criteria, eligibility criteria is you must marry or in de facto relationships. And another important benefit of this this visa is the applicant get the bridging visa until the application is processed to continue to live in Australia. So main advantage of this subclass is you can apply this visa either you holding any visa for Australia, even if you are Section 48 bar, or if you are no longer having any visa in Australia, but still, but you have to satisfy some requirements like Schedule 3 of migration, Australian migration regulations, that there are compelling need to grant of this visa for you. You are in a relationship with the Australian resident or Australian citizen person. So you get the full work right on this visa, and especially if a bridging visa granted to you after your previous uh, s- uh, previous supplement visa. So any substantive visa granted to you before the application of partner visa, then you will get bridging A. Otherwise, depends upon your circumstances. If you are already on some another bridging visa, so then bridging C will be granted. If you're not holding any visa, so it depends. So maybe they grant you the bridging E as well. Uh, so it all depends upon your migration history and your immigration status at the moment when you lodge your applications. Uh, if you granted bridging A and you need to travel overseas, in that case, you can't directly travel overseas on bridging A. You have to apply bridging B to have the travel right if you want to travel offshore during the processing of your partner visa applications. So eligibility, as I said, if you're not holding any visa or if you are previously on the bridging visa for any other application while lodging the partner visa application, then you definitely need to specify the Schedule 3 criteria. So Schedule 3 criteria is you have to satisfy the case officer that why you applying this visa. Um, while you was previously not having any substantial visa status, and how compelling and compensate your circumstances are. Uh, so all these things have to satisfy, which is described under Schedule 3 of migration regulations while lodging this visa category. So definitely, if such condition arise, so you definitely need some migration assistance from the registered migration agents or the lawyers, uh, uh, so that your visa application should not refuse while you lodge. Because you have to be very careful when lodging this visa, because fee associated is quite high, more than 9,000. Uh, the itself the visa application fee with the department. The most mandatory documents when you apply a partner visa, the main requirements are identity documents, sponsor documents, health documents. In identity documents, the major documents are like your passport, birth certificate, national ID, uh, mortgage, marriage certificates. In sponsor documents, his Australian passport. If he's not Australian citizen, then his overseas passport with a permanent visa grant letter and evidence of residence as well. Health declaration, police clearance check, and medical examination is mandatory when you apply for this visa. In terms of relationship requirements, as I discussed before, the financial evidence, household evidence, social evidence, and commitment evidences are required, like your relationship statements, joint account statements, shared rent payments, shared insurances, money transfer if you have done, tax returns to prove you have the same address, lease in terms of lease or mortgage documents, utility bills, uh, shared address proofs, household photos. So I also include the photos of your marriage ceremony, anytime you spent with the family and friends, and your own photographs. So everything must be supplied when you lodge the applications. Uh, Apart from this, you can also include your travel itineraries, invitation, wedding invitations, social media post, and triple eight form. Obviously, very important and mandatory as well. At least two need to supply, um, and evidence of long-term plannings you can state in your relationship statements. And your relationship statement, when you're drafting it, you must include how you met first time, where you met, when relationship becomes serious, what was a key milestone in your relationships, like meeting family, engagement, and then move on. Your living arrangement, financial arrangement, how you're going to spend life together, future plans in Australia, or any separation evidences, like if you were previously married, must attach your divorce certificate as well. So all these statements must be mentioned in your relationship affidavit. And the statements, most importantly, is must match sponsor statements and timeline, because both of you have to supply and share the same sort of statement when you're lodging something with the department. The most important documents are 888 forms, which are statutory declaration, which is a legal declaration from Australian citizen or PR supporting the relationship. So the best practice is you must supply at least two of these forms. More than two are still acceptable, but at least two should be there, and should be written by your close friends, family members, colleagues, or any community leaders. And obviously, they must be the Australian citizen or permanent resident or eligible New Zealand citizens. And on 888 forms, they must mention that how they know the couple, how often they met, and events attending together, their opinion on your genuine and ongoing relationship. So everything have to be declared on these forms, and also attach their Australian passport or offshore passport with PR visa grant must be attached with these forms, which is very, very important. And last one is the permanent stage of this partner visa. So if you applied 309 visa, then the permanent state is subclass 100. If you applied 820, then next stage is 801, which I already explained. So this permanent stage is guaranteed, usually assessed around after 2 years when the initial visa was granted or lodged. And the permanent stage, the department usually check for, are you still living together, still relationship in genuine and ongoing, and any new evidences since lodgement they're looking for, they ask while processing these applications. So you can provide while lodging this visa updated joint bills, the recent updated photographs and travels, and you can also share updated 888 form as well. And if you got any children during the relationship, so you can also provide that birth certificate of the child when lodging this first class, this subclass, and then the permanent state is granted accordingly. So now I explained all these visa categories, offshore and onshore. Uh, Now I'm going to discuss the major reason why partner visa applications are refused mainly. Generally, the main reasons are like weak relationship evidences, no proof of living together, especially if you are applying partner visa on the basis of de facto relationships, then definitely you need to provide such proof. Inconsistent timeline and contradictions, the sponsor and the applicant, poor and bogus documents, if marriage of convenience suspension, if it no longer exists, or lack of social recognition. Uh, Another reason could be the sponsor is not eligible. The sponsor eligibility I explained previously. If you sponsor someone within last 5 years, or if convicted by any offense, that could be the reason. Applicant itself character assessment, and if sometime in terms of section 56 request they ask some requirements to process your visa application and do not respond on time, and schedule 3 issues which I described recently. And yeah, these are the main reason why this visa is refused. And you have to be very, very careful when lodging a submission and evidentiary document to support your relationship. So must be genuine, of course, with proper documentation. And the department, in terms of section 56, they may ask more information if they're not satisfied with the requirements what you shared with them. So like if relationship is new or of short duration, you recently married and lost the applications. In that case, they may require more evidences, or you provided limited evidences of living together, especially in de facto relationships, and couple has spent limited time physically together. So in such cases, they may ask more information in terms of your shared bank account, bills, rent, mortgage, any other social aspect of relationships, or any other evidences if they find which is more favorable to support your relationship for the visa processing. So this is all about the partner visa application in Australia. So if you have any questions, you curious about the case, you are not sure which visa subclass you need to apply, and any question related to partner visa categories, so you do contact us. Our contact numbers are displayed on the screen, so you can contact us on direct send message on the email info@cca.com, or you can directly contact me on 0451 This is my direct number, or you can see me also in the Melbourne office of CECA. So thank you very much for today. So this is all about the visa. So if you have any question, please do contact us. Thank you very much. Thanks for your time for today.